Fast forward, you need to come out channel so how say a GH Politics Avenue. Podcast stories are trending because big headlines near Jemre na EDB Exomo ewa hase ni diamni ahun braxi mu se ene EDD kan ya me stress obeti ma subscribe to the channel. Hit notification bell no so ma me share na for front so answer into Kpebu. Ni diamni ahun braxi mu unia me stress yen ko yensimu. Ye ko yensimu a unia for once. Lawyer Martin Kpebu etimi e defend eye Tukunu enya asem koto akra. O say onwa. O say. Opong se maame no yeyi no free eye na kunya so no as chief justice no ofo aso. Na mo process ye di maame ne fam no de. Eno de bi wo ho na teach makakra. Wajemre oboyi nchiremu yensemre emunwram yenhwe ne yeko ane de ba. Ha EGH Politics Avenue.
So if you look at the Westbury formulation and you apply, it is either you are saying that there is a rule of law that the committee did not apply. Two, that you have a legitimate expectation and that was not, respected. Or that there was procedural impropriety or there was a breach of the rules of natural justice. It is not for a high court to substitute. So immediately you bring the question of fairness. And that's what the committee did not meet that legal requirement. That becomes a problem. The court does not have the power to engage
in the jurisdiction of the High Court in this matter.
Completely.
Okay.
Foreclosed.
Key one, is it the thing is, quick one. The backdoor procedure that was flagged in the Aban case, as Eduji referred to, I don't think it's playing out in this matter.
Why is that?
I have said that when you look at the reliefs were couched in a tacit judicial review application reliefs. But I have faulted some of the grounds. And I think these are matters the lawyers should work on. But the thing is that, Alfred, on this table, what I am finding it difficult to accept is a submission by Eduji and some other people in the media that there's no way around the Article 146 to question, in fact, the procedure the committee adopted in arriving at its recommendation, arriving at
show us the way, Braco power.
I have said that the Constitution, when you are reading, you are just picking Article 146 and isolating it. And I'm saying that the Constitution as a political document, you should read it as a unified whole, thereby ensuring that no one provision operates uniquely or in isolation. You must get them in tandem. And I have noted that the Constitution is anchored on key principles. And those principles, if those principles are missing in any decision that is arrived at by any committee, established, properly so-called, established by the Constitution or an act of Parliament, any aggrieved individual can't question the procedure. However, I have also noted, Alfred, and if you realize that appeal must clearly or should clearly have been given to you, the right to appeal should clearly have been given to you by the law. And I have said that Article 146 has no room for appeal. Be that as it may, you can question the procedure if only you have legitimate grounds. And I think the argument should not be pushed around or be peddled in the media that there's no way around it. That is, I see that as selective and cagey and narrow interpretation of the Constitution. And we must not, saddle ourselves with that. We must open up. I think
to be clear, did you say we can't question at all, or is the High Court? Because for the Supreme Court, you question. The decisions show how we are questioning the processes.
And that's what I said, that you see, in terms of questioning, it's the High Court. It's foreclosed.
What is foreclosed?
So it can be done in the Supreme Court. I'm not hearing him saying that you can't question at all, but it's the venue.
The venue. No, the thing is that
let's not run amok. We have a specific matter before us. A judicial review. The High Court jurisdiction has been invoked. And I submit that the High Court jurisdiction is completely ousted.
So when they go, maybe they can...
Please, that is not a matter, it's not a matter for now.
Okay. Yes. I don't subscribe to that argument.
Okay.
I think legitimately the High Court has jurisdiction to hear a judicial review application.
Okay.
Particularly Because we know that when it comes to matters...
That's not what we are fighting. We're saying this Article 146 matters she's raising. Are they for the High Court judge or for the Supreme Court? Nobody is saying...
No, I think for me, I think she's in the appropriate forum.
Okay, right.
She's in the appropriate forum. It is open. I understand, individuals like Edu and Co in the media who have a different position. But the thing is that usually your argument is based on where you stand. And where you stand will also inform what you communicate. But so, largely, she is properly before the courts. I have issues with some of the grounds. It is something the lawyers will have to work on.
Okay.
But I think she has every legitimate ground to question the procedure adopted, but not the conclusion of the committee.
Okay. Let's just quick one on this, the jurisdiction of the High Court. I don't think that there's a blanket statement shutting down or questioning the powers of the High Court, but with specific reference to this Article 146 issue. Does the High Court, from where you sit, have the jurisdiction to hear this matter before it? Specific to this Article 146 work?
Oh, to be very honest with you, lawyers, we like to be guided generally by Supreme Court decisions, right? Because that's the final court. Unfortunately, on this particular one, I don't seem to remember how the Supreme Court has clarified which aspects the High Court can deal with, right? Yeah, so there's not much. Braku Powers agrees that there's no decision that says the High Court can deal with this part and not that part. So now that she has entered, if the lawyers, for the Attorney General will raise the matter of jurisdiction, and when it is done, you see, just like the other one, the removal itself. You see, Dr. Sremsai raised some preliminary some questions to be set down to the Supreme Court. So in the same way, in this case, that's likely to arise. Then that one will be set down for the Supreme Court. Then the Supreme Court will show the way. That one, then we'll learn from it, because matters like this, naturally, if you ask me, as a lawyer, I can espouse a view. But because we've not developed the law that well, the Supreme Court may have a different view. Let's be patient about it. Well, as I've always stated, I wish we would get closure on this matter, right, far earlier. But it appears Justice Torkornoo is not willing to have closure. She wants to continue going and going. So let's grant her her right, right? Yeah, she has a right to challenge. So when they get in there, the matter of jurisdiction may be raised again for the Supreme Court to determine. And when the Supreme Court determines it, then we'll know. Whichever way, bottom line is at the end of the day, she wants to hold the committee accountable. And that one, she has a right to. As for the accountability, it can never be denied. So whether it will be done in the High Court or Supreme Court, we don't know. But so accountability...
Question.
Yes.
After holding the commission accountable, and what happens? Will she be reinstated? I'm just asking. Is it possible that she can hold them accountable and that would sort of override the decision that has been already taken to remove her? Is it possible? I'm asking you.
Why? Unless it's so egregious.
Because I'm asking myself.
Theoretically, unless it's so bad, what went on there is so bad that no human institution will countenance it, then that's how she can win. But with what we've seen, there are a few problems. I think, look, in all of this, what she has most going for her, in my estimation, is the failure of the president to give the reasons for the Prima Facie. Yes, that's that one.
That's the subject matter of the judiciary.
No, she's raised it. Hey, let's go.
Sinner, if you look at
I'm paraphrasing. Let me show you why she's raised that one there. It will come to haunt us for years to come. Because when that was done to Chachuchikata, we're up in arms that the judiciary didn't do well. They didn't do well, okay? They didn't do well because the Supreme Court itself, when Chachuchikata was not given the Prima Facie thing, the Supreme Court itself said the trial judge's failure to give the reasons for the Prima Facie ruling just shows bias, malice, thoughtlessness. Yes, after saying all that, at the end of the day, he said, but it's not sufficient to cancel the whole trial. So as for, and that's 2003, 2004, Chachi Chikate's case. 2003, 2000. So the Supreme Court itself having set that standard that if you don't give reasons, you give way for people to think that you are biased, you are thoughtless, you are malicious. I thought that this one, we should have done it. So as for the failure to give Torkornoo the prima facie reasons, it's bad. It's bad in this process.
No,
but
I
it is
think
not
senior,
sufficient.
with respect. No, but senior, you see the reliefs.
Which
here.
one?
No.
And I'll justify. Okay, you read.
Yeah,
Okay,
so senior,
No, hold on.
I listen there.
No, hold on. The specific
It
reliefs,
says,
yes.
please take note, so and so.
Yes.
For the following reliefs.
Yes.
A, an order of certiorari bringing up into this court for the purpose of being quashed and for quashing the proceedings of 15th of May 2025 and the entire proceedings and the outcome of the Article 146 set up to consider petitions to remove the applicant, chaired by Puama JSC. That's relief A. B, an order of certiorari bringing up into this court for the purpose of being quashed and for quashing each and all of the three reasons and grounds given. So grounds and reasons.
Yes. But if not, so when you read in, so now
And so if you go through all the reliefs, he had never questioned, for the purpose of this judicial review, the fact that the prima facie was without reason. In fact, she herself says reasons. Please, with respect. It's not here. At least for this judicial review. Unless, of course, it's a different process. If it's a different process, that's fine.
Let me respond. Please, when you read it, she tells you that that is the foundation. We can get the paragraphs. So what you are reading is the top. It's in there. She says,
reliefs.
Yes. So she's saying that, you see, in law, what she's saying is that in law, you can't put anything or nothing, it will collapse. Mark 4 versus UAC. So lawyers, so she's saying that there's, I read it, ADJ also read it. So she's saying that the relief is the final outcome. Why is she asking for the relief? The reason she's asking for, she says you have no foundation. So anything you put on it will collapse. That's what she's saying. There are several paragraphs where she says she was not given the reasons for the prima facie. So her case is that once she doesn't have the reasons for the prima facie, you can't even do the hearing. And I'm saying that one she won't win, because in the same Chachuchikata case, what they did was that they just berated the trial judge for not giving the reasons. But they said it's not sufficient to cancel the case to say, Chikata, because you were not giving reasons for prima facie, walk free. And that one was even a criminal trial, where Chikata's
liberty
excellent. So that one was a higher things were at stake, liberties, right? Personal liberties. Yeah, the Supreme Court said when Justice Henrietta Aban didn't give reasons for the prima facie, though it was bad, it was thoughtless, it was malicious, it showed bias, etc. But still, the fact that Chikata should open his case was a good decision. It should stand. And then ADG yourself, you've been citing the other case, 2017. Is it
Michael Asamoah?
But yes, so you also have it. So she will not win. But that one, it will come to haunt us for years to come. That if in 2003, 2004, we said failure to give reasons is bad, it's not good for our governance, why are we repeating that in 2025? That's a separate argument, but that's not sufficient for her to win the case.
Okay.
So let's go on. So now the thing is that, so when you
can I chip something? No, just chip something.
Unless that is on the permission of Martin Kpebu.
Sina, with respect to enrich the conversation.
Yes.
You see, she grounds the reliefs, the 4 reliefs, on specific grounds.
Yes.
And the grounds start from Roman numeral 1 to 10.
Yeah.
Each one of them, it is in respect. So, for instance, ground 1, that all of the alleged findings, and ground 4, recommendation of the committee set up by the president, not the prima facie. Roman numeral 2, the findings and recommendations of the committee. 3, the first alleged finding and recommendation. 4, the first alleged finding and recommendation of the Puaman. So throughout, the attack is the Poor Man Committee. The findings and recommendations. Findings and recommendations. In fact, there is no specific instance that she even brings up the issue of the prima facie determination by the President and the Council of State. And I am making
several paragraphs.
When you read it, the affidavit is there.
Judicial we are doing law. A judicial review has reliefs and grounds.
You've had your so let's go. Look, even before paragraph 94, before paragraph 50, she raised it. But look, another lawyer who has read it says we should start with 94. So let's go to 94 and I'll tell you that before 50, I read it. So let's go straight to 94.
So 94, where exactly are you looking at?
94, I'm just scrolling. Don't say she didn't
it's 94. Just look at
it's 94.
That the proceedings, the refusal to give me a copy of the alleged prima facie determination. That should have determined what case I was to answer in the proceedings. And the current refusal to also give me a copy of the alleged report allegedly recommending my removal from office as Chief Justice, and the alleged reasons communicated by the Secretary of the President as the reasons given by the Prima Committee for recommending my removal as Chief Justice from office show a reckless disregard for my rights as a citizen to procedural and substantive justice, and a total lack of any reasons for removing me from office as Chief Justice found in the petitions referred for hearing, and an insistence on presenting any sham excuse for removing me from office while hiding behind the veil of in-camera proceedings, and a refusal to give me a copy of the report as if I do not merit the minimum humane treatment of even being given a copy of the record explaining the reasons for taking my rights and entitlement for me. So after that's the paragraph.
And before that, even before paragraph 50.
Martin,
but she has said that.
Martin, can I quickly, can I just clarify a few things? Let me clarify. You see, when you do a judicial review application, you look for two things, two substantive things, the reliefs and the grounds. The affidavit provides the factual matrices. At this point, what the court is called upon is to give you something, and that is what the relief does. The grounds provides the legal basis why you are seeking for those reliefs.
Oh, yes. So that's
and the grounds, Senior, can you point out where in any of the 10 grounds formulated that she challenges the prima facie determination? If you do that, I would yield to you.
So, perfect. Now let's go.
Help me out.
Let's start. Paragraph 34.
No, reliefs. I say reliefs and the grounds.
So when I get to the grounds, I'll show you where she said there's an aberration of Article 19, Clause 13 and 23. That's what she's referring to. That she's not had proper justice. 19, 13, and then 23. You see, let's get this. The fact, I've been very clear that the removal is correct.
No, I'm not even disagreeing with you. I'm just saying that we should put the law.
View. Even this is what I'll say. Even if I went to the Supreme Court, this is what I'll say.
I don't disagree with you.
Of a removal, I support it 200%. Okay, it's just that the process you couldn't have gotten 100%. Look, if you want to understand this thing, all of us seated here, even including the professors, how many times when you were in university did you write exams and you got 100%? You won't get 100. So that is the principle we are showing that the little things that went wrong, but we are not saying it's a failure. It's just to show that the committee couldn't have, the president didn't get 100% in the process. And that one we have the right to show, because it's not good if in 2003, 2004, the Supreme Court says if you don't give reasons, you appear biased, you appear thoughtless, you appear malicious. We shouldn't do that more than 25 years on. We shouldn't do that. That's the point I'm making. But it doesn't mean her removal is correct. No, that one, even if I was called in the Supreme Court, I'm sure I can justify my position that they themselves said it. And so today, you won't find the Supreme Court to say failure to give Torkornoo the prima facie ruling is good. The Supreme Court would never be able to do that, considering their own decision in the Chachu Chikata case. And the whole nation was behind Chachu, saying that, why did the trial judge fail to give Tatuchi Carter reasons for saying he should open his defense? So if more than 20 years ago, the whole nation was supporting Tatuchi Carter and this, and how can it be right now, more than 20 years on, that, failure to give Torkornoo reasons is kosher? We can't do that. We will not do that. Even the Supreme Court itself cannot do that. Except that
cannot do what exactly?
Cannot say that failure to give Torkornoo reasons is good. That's the point I'm making.
Senior, once again, the injunction application, read my Lord Justice Tanko's view, and let me read it. In the injunction application, no, please, can I read?
Okay,
hold on. The ruling of Justice Tanko.
Yes.
On the injunction, she raised the specific issue of she not being given reason for the Prima Facie. And this is how my Lord Justice Tanko canvassing all your grounds. He said, quote, the next ground on which the applicant invites the court to restrain the committee is that the Prima Facie determination was not judicious, as it was rendered without reasons. I have cautioned myself against prejudicing the substantive.
We and some of the team course watching on some not so Jimre or Harrison so body and the Adumbi Edumania. It was about Remunia Smoke Sukra. GH Politics Avenue.